In bankruptcy, what is Chapter 15? Chapter 15 Bankruptcy is a chapter to U.S. bankruptcy law added in 2005, which helps to streamline the process when businesses or debtors outside the U.S. have debts inside it. In an increasingly global financial world, it's quite possible for foreign debtors to owe money to various lending institutions in the U.S., in addition to owing money in another country. When a debtor cannot repay debts, this form of bankruptcy helps to address the issue of rights of U.S. lenders in foreign courts, rights of foreign lenders in U.S. courts, and rights of debtors in U.S. courts to obtain some relief from debts that can't be repaid. A person filing Chapter 15 would file bankruptcy in his or her own country first, and the filing in the U.S. is considered a secondary or ancillary filing. Chapter 15 is not the only option for foreign debtors. A significant amount of debt could make it more reasonable to file Chapter 7 or 11 instead. This choice would probably only occur if principal debt is to lenders within the U.S. When most of the debt owed is in a person's home country, borrowers would file Chapter 15 to essentially notify U.S. creditors of bankruptcy status. There are several things that occur as a result of filing Chapter 15 bankruptcy. One or more representatives of U.S. debtors can participate in the principal bankruptcy proceedings in a foreign court. Depending on how debt repayment in the court is structured, if there is debt repayment, these representatives might be able to obtain some repayment for debt. In any case, any U.S. lender's claim to repayment rights would be considered with the claims of all foreign lenders. This access to the foreign court works both ways with Chapter 15. Foreign lenders or their representatives gain the right to present their cases in the U.S. courts. A judge creating any kind of repayment plan would have to consider the claims of these lenders with those of U.S. creditors. This two-way access helps foreign and U.S. courts determine how best to apportion any payment. In addition to making it easier for courts in the U.S. or elsewhere to work together to determine how to resolve claims, Chapter 15 gives the borrower an opportunity to claim and clear all debts at the same time. Foreign bankruptcy might not apply to U.S. debts otherwise, but by filing bankruptcy under this chapter, a debtor can at once declare insolvency in multiple locations. This gives the person or company a chance at gaining immediate relief in every place where money is owed. This type of bankruptcy is complex to file. It usually advised people or corporate entities have legal representation in the courts, and they may or may not need to travel to the U.S. to make a court appearance. Anyone considering this form of bankruptcy should recall that it is necessary to first file bankruptcy in the home country, where principal debts are owed.